Today we're talking record retention, and we have Teresa Schmidt joining us from DPI. Although, have you guys officially changed your name yet?
We are still going to be DPI. We're the Department of Public Instruction, but we have officially changed our working title of our division. We are now the Division of School and Library Operations, and I am a member of the Bureau of Libraries.
Okay, but we can still say DPI
You
then.
can, yes.
Perfect, perfect. So Teresa is a public library administration consultant, correct? Um,
Correct.
all right, so she is joining us today to walk us through some record retention information. I sent some documents out ahead of time. We've got those in our meeting notes, so you can always refer back to them if you need to. But we'll walk through record retention with Teresa then.
Great. Well, thank you so much, Emily, for inviting me. I am going to share my screen.
I just,
Okay, can you guys see my slide now?
yes.
Excellent. Okay. So, as Emily said, I am the Public Library Administration Consultant for DPI. So, I answer a lot of questions about public records and about the open meetings law. I've been getting a lot of questions this summer about public records retention. So, I'm glad to talk about this with you guys. This gave me some good motivation to get some slides together to talk about this in kind of a general way. It's a lot to cover in a short period of time. So, this is really going to be kind of a high level overview of your requirements. I do invite you, if you have questions as I'm going, go ahead and put them in the chat. Emily's going to monitor that for me, and I'm happy to take a pause and answer some questions as they come up, but also we'll have lots of time for questions at the end. So let's get started right away. I am actually going to turn my camera off just so that I can focus on my presentation, but I'll pop back on at the end for the question session. So here we go. Wisconsin Public Libraries and Records Retention. As I said, there have been a lot of questions about this recently. I'm actually also going to be doing a presentation at the WLA conference in October about records retention and about the open meetings law. So if you have more questions about open government, you can check me out there, or you can also reach out to me anytime, and my contact information will be at the end of this presentation. So today's presentation, I'm going to try to keep relatively short. I'm hoping to hit about 30 minutes, and then we'll have plenty of time for questions afterwards. But here's some of the things I want to talk about with you today. So we'll talk generally about your statutory requirements for public records. We'll talk about the differences between public records and library records. We'll talk about preparing for records management, including the general records schedules that hopefully your library has adopted or will soon adopt. We'll talk about the life cycle of public records, and we'll go through a little bit about handling public records requests, and then I'll provide you some resources for further information. And Emily has already provided a lot of great stuff too that I do recommend you check out. She had shared a recording of a presentation my predecessor, Shannon Schultz, did not too long ago. And Shannon, in that presentation, talked a lot more about identifying records and non-records and things like that. So her content was a little different than mine. So if you have more questions, you could absolutely check that out as well. So open government laws, such as public records requirements and open meetings laws, are sometimes called sunshine laws. They basically exist to ensure that citizens know how their government is operating and that there's transparency in how we are spending tax dollars. So you, as a publicly funded institution, and public libraries and public library systems around the state are subject to public records laws. Those laws are defined in the Wisconsin statutes, sections 19.21 to 39. And you must comply with those statutes by properly retaining and managing your records. And in general, all records of your organization are presumed to be open to inspection and copying unless they fall under a specific exemption. So keep that in mind whenever you're doing work for your library. Anything you do can be subject to scrutiny because you are publicly funded. So don't write an email that you wouldn't want read back to you. Don't create a document that's not necessarily related to your work on your work computer. Just be cautious about how you are creating records in the first place. So what is a record? Generally, anything that provides evidence of the workings of your organization is a record. So public records are created or kept in connection with an official purpose or function of a public agency, regardless of format. So records can be printed documents, they can be electronic documents, they can be maps, they can be audio recordings, videos, and the format does not matter as much as the content. Not everything you create is a record, though. So records don't include drafts or your personal notes or preliminary documents that you might have created only for your own use. They don't include things like published materials or copyrighted materials. The reference materials sitting on your desk are not public records. They do not include things that you haven't solicited, such as listserv emails, even if you subscribe to the listserv, or newsletters or junk mail or spam emails. Reference copies of things that others have created are not your records. So if your town created a report and you have a copy sitting on your desk that you refer to, that's not your record. That's your town's record. So a lot of this is contextual. Your draft documents are not a record if you are the only one using them, but if you share that draft with someone else and you start adding comments and debating policy and talking about the development of something within that document, then it might become a public record. So if you want to know more about what's a record and what's not, I recommend that you check out the Attorney General's Public Records Compliance Guide, which I will talk about quite a bit today. Or as I said earlier, you can watch that presentation that Shannon did that Emily shared the link to. So earlier I mentioned that records are presumed to be open to the public unless they fall under a specific exemption, and library records are one of those exemptions. I want to mention them separately because your library might want to have separate policies and procedures for them. I was helping a library not too long ago that was drafting a new public records policy, and they were trying to include information on library records and how to prove that a custodial parent has access and things like that, all within their public records policy, and it got confusing kind of quickly. So I recommend that you have a policy about your public records and you have a separate policy dealing with the confidentiality of library records. So library records are records that specifically identify the identity of users of your library and the resources that they use. And they are identified as confidential under Wisconsin Statute 43.30. So they are one of those exemptions to a public records law. All library records are confidential under Wisconsin statute. That can include things like circulation records, video surveillance format that shows people coming and going from the library, computer use logs, program registrations, summer reading logs, all those kinds of things are something that shows the identity of a library user, and those are confidential under the law. And library records can only be disclosed by a court order or under some specific exemptions, such as sharing information with another library for interlibrary loan, or to another person that the user authorizes. So if I went to my library and said, I'd like my spouse to be able to pick up my holds, please, that's okay. You have to share library records of a child under the age of 16 with their custodial parent or guardian. So you may need some procedures for proving that that person is a custodial parent or guardian before you release those records. And then there are certain exemptions that you can use to disclose records to law enforcement or a collection agency. And that includes when law enforcement is actively investigating alleged criminal conduct that happened on the library property, or if you as the library reach out to law enforcement and request assistance with something. In those cases, you can release video surveillance footage. Otherwise, you cannot just have law enforcement be able to regularly monitor your video surveillance. I had this question from a town law enforcement agent not too long ago. They have been having some vandalism issues, and they wanted to point a video camera at the entrance door to the library, and they wanted the local sheriff to be able to monitor that at any time. And I said, no, those are library records. The people who are coming and going from the library, their identity is protected by state statute. The library staff can monitor that camera for you, and then they can decide to reach out to you for assistance with investigating something that might have happened and release only that footage to law enforcement. But they can't just give blanket access to law enforcement to those records. So now that we've talked a little bit about what records are, let's talk about preparing for managing those records. Having some good systems in place is going to make your job a lot easier, and you're really going to appreciate that if and when you receive a public records request. So you are going to need to post a public notice about your records, you need to adopt some record schedules, and you need to develop some filing systems for your records. So the records notice is a requirement of the statutes, 19.34. This is an example from Milwaukee Public Library. It's probably kind of small, but the list here that I've given you tells you what needs to be in that notice. This does need to be posted in a location accessible to the public. And you do need to have all of this information in that notice. And this is important because some libraries in Wisconsin were recently sort of tested on this by a community organization that was trying to sort of catch libraries out at not following the public records law. So do make sure you have your records notice published, posted in a public place. Most people put it on the bulletin board where they also post other legal notices, for example. And it just basically, it can be short. This example's from Milwaukee Public Library. It's probably a little longer than it needs to be. In my library I used to work at, we had a very like small half sheet piece of paper that just had information stating that the library director is the custodian of records and our hours and the costs for copying records and things like that. So then you need to start considering how long you're required to retain records. Wisconsin Statute 19.21 describes some general retention requirements for local government, which you are part of. And it requires a municipality to pass an ordinance that prescribes the length of time records are kept, which has to be at least 2 years for certain utility records and more than 7 years for other records, unless shorter periods have been fixed by the Public Records Board. And it also requires you to notify the Historical Society in writing at least 60 days before you intend to destroy obsolete records. So you and your municipality or your county or whoever your parent agency is would have to develop and get approval for your own records disposition authorizations. And who wants to do that? Nobody wants to do that. This is not something you want to get involved in. So the state has tried to make this easier for local municipalities, and we have tried to make this easier for libraries by developing general records schedules. They provide for consistent record retention practices without the need for developing your own RDAs. And that really simplifies the process of records retention and disposition. So Wisconsin units of local government are not required to adopt GRSs, but we highly recommend that you do so. It doesn't make any sense to try to develop your own. So what I've linked here is the general record schedule for Wisconsin public libraries and public library systems and related records, which was approved by the Public Records Board in 2017. So a lot of your libraries have probably already adopted this. There were earlier versions of this GRS as well. So look in your files and see if you know that your library has adopted it. If not, you're going to want to do that. And I'll talk about that in a few minutes. But let's talk a little bit about what this GRS allows you to do. So here's an example of one of the pages of that library and library systems GRS. And you'll see in here charts that describe a record series title and what you can do with those records. So let's look on this one at the request for reconsideration of library materials. And it describes what those records might be. It indicates that they do have personal identifiable information in them because it's usually a form that requires some contact information from the person submitting the form. It labels it as not a confidential record, which is important to note. I've been asked that several times about records reconsideration forms. They are not confidential. They are public records subject to disclosure. And then this GRS provides you with a minimum retention and disposition requirement. So you must retain this item for 6 years and then destroy it as a confidential document. And the event after which you have to start retaining it is the time that the decision was made by you or your library board on how you are going to respond to that request. So destroy confidential is something that you will see for any record that has personal identifiable information. That means that you have to either shred the paper document or destroy or delete the digital records so that you're not retaining that PII. So this tells you a few things, obviously how to handle the record, but simply the fact that the record exists in this GRS is information for you to know that, yes, this is a public record and I do need to be retaining it. Here's another example page from GRS, patron registration and application forms. I'm dating myself a little bit, but when I first started at my previous library, we had binders and binders and binders of patron application forms that we were retaining forever. You do not need to keep those things any longer because they're in the GRS, and the GRS helps you know that you can retain those only until the information has been entered into your ILS, into your computer system, and then you can destroy those as confidential records. Now remember that these minimum retention and disposition information provided in the GRS is just that. It's a minimum. If you need to keep records for a longer period for the purposes of your library's business, you can. You just cannot keep them for shorter than the periods listed in the GRS. Here's another page from that same GRS, and it's talking about other kinds of records that you need to retain, such as reference requests. Those are things that you can destroy immediately after you've fulfilled the request. Programming and events files, contest entry forms, meeting room agreements, all of these things are public records with different retention periods required. Some of them you're going to be destroying right away as part of your practices based on confidentiality of library records, and some of them you will need to retain for longer. But the important thing to know is that most of these things are of no interest to the Historical Society. So if you go back to what the basic statutory requirement was for retaining things for 7 years and then asking for permission before you destroy them, using this GRS helps you avoid that process. The Historical Society does not want your summer reading registration forms. So why do you need to wait 60 days in order to destroy those? So you can skip that process if you have adopted the GRS. In addition to the GRS for public libraries and public library systems, there are things that you need to address that are more broad types of documents, and those are not all addressed in that library GRS. But if you look in the library GRS at the final pages in there, it does give you some information about where you will find other relevant things. So previous versions of the library GRS did address some of these things, like policy manuals, board meeting minutes, correspondence. And to simplify things, what we decided to do, we meaning our division back in 2017 when our records people developed this GRS, is allow libraries instead to use the statewide GRSs, which have already been established for some of these general business records. So the last pages of the library GRS will help you understand where to look for some of those things. You will see a page in the GRS, not this one, a different one, that talks about lists of records that are closed. And that means it's been determined that they are either not public records or they're no longer records categories that we use. And so you don't have to worry about those anymore. This is another example page that talks about administrative records that are addressed now by other statewide GRSs. So if you're looking for the retention period for your policy manual, it says here that it was superseded by ADM 00023. That tells you can go look in the administrative general record schedule for a retention period for policy manuals. And there are statewide GRSs for records related to administration, budget, payroll, purchasing, all kinds of things. And you can look at the revision made column of this library GRS to help you determine where to look in the statewide GRS for guidance. Note that in those statewide GRSs, some records do still have a requirement to notify the State Historical Society before you destroy them. Board records are one of those examples. But again, remember that the GRSs provide a minimum retention period. Many libraries would choose to retain all of their library board meeting minutes indefinitely and keep those as a permanent record at the library as a record of the library's history. You do not have to destroy things simply because there's a minimum listed on the GRS. You can keep things longer than that as long as you are properly retaining them in case of a records request from the public. So as I said earlier, this most recent GRS for public libraries and public library systems was approved in 2017. Most libraries in Wisconsin, I believe, have adopted it. I do not have a way to look that up for you, though. I have not been able to find from the Public Records Board that they have a good way for you to reach out and say, did we do this or did we not? So if you do not find records in your records about adopting this GRS, then you may want to do it as a just to cover your bases. And of course, it's government, so there's a form for that. And I have linked that form in the resources at the end of this presentation. Most of the time, your municipality has already adopted the statewide GRSs, so you do not, in my understanding, need to fill out this form for every single statewide GRS because your municipality probably has already done that work and you are part of that organization. But if you have a question about that, you could talk to your municipal clerk. And now that you know how long to keep your records, you can see that it's going to be important to have a system for organizing them. I don't have a lot of time to cover this today, but I did want to highlight the fact that Emily shared some links to the Wisconsin Historical Society records management guidelines. That link is also going to be on my resources slide. You do want to make sure that you're organizing and filing your records consistently, because that's going to help you adhere to retention requirements. That goes for everything from file naming of your digital records to the structures of your physical files. It's generally recommended that you use the same naming conventions and file structures for physical and digital records. Please don't name all of your agenda documents agenda, agenda 1, agenda 2. That's not going to be helpful when you go back later to try to evaluate those records and respond to a records request. So do think carefully about how you're storing electronic and paper files. And again, remember that GRSs are minimum retention requirements. You can absolutely keep some records longer than those minimums. Just a brief word about personal property. As I said at the beginning, you want to be careful about how you are using your library's resources to create records, because all of them become public records. So not everything is a record that's subject to disclosure. There's some like transitory records like, hey, an email from your colleague that says, hey, do you want to go out for lunch today? Or, like the the two-factor authentication code that you needed to log into something. Those kinds of transitory records don't necessarily need to be retained. However, if you're doing those things on your public work computer, they could be subject to disclosure, depending on the nature of the records request. So the best thing to do is only do work things on work things. Use the devices that your work provides, your computer, your cell phone if you've been issued one, etc. If you need to use a personal device for work business, make sure you're using your work provided accounts. So don't use your personal email account to shoot off an email to your town supervisor. Use your work account, use your work's Outlook account or whatever else has been provided by work, because then those records are retained in your usual work systems. Personal email sent or received on an authority's computer system is a record subject to disclosure, even if it ends up not having to be disclosed. So don't take the chance, make sure you're keeping things separate. So we've talked a bit about the life cycle of records, and this is kind of a summary of that on one slide here. You are going to be creating records or receiving records in the course of your business. You need to determine what the retention period is for those records by looking at your GRS. And then you need to file and keep those records with an organized filing system. You need to protect those records. Active records that you use in your daily business, make sure that you keep them readily available, but are also retaining them as a record. Make sure you're backing up your files. Make sure you have a system so that your records are not lost when you have employee turnover, or you move to a new computer, or you switch email providers. You need to be storing some things using some practices you establish, which might include cloud services or external storage, so that you're not losing documents when changes happen within your organization. And then you need to dispose your records according to the general record schedules or other applicable RDAs. And if they are personally identifiable information on those records, you do need to destroy them confidentially, so shredding paper documents or making sure you are thoroughly deleting digital ones. So let's talk a little bit about handling public records requests. Everybody's going to get one at one point or another. Sometimes they're easy to deal with, sometimes they're a challenge. So let's talk about some of the guidelines and assistance that's available. The Office of the Attorney General periodically updates the Wisconsin Public Records Law Compliance Guide. They just did that in June of 2025. I haven't been able to find any information about what was revised. I don't see any major changes, but it's a 100-page document, so I can't guarantee it. So make sure you're looking at the latest version of the compliance guide when you need it. And this is a great resource. It has a lot of detailed information about responding to records requests, including a 4-step approach that you can use to determine whether some records or parts of records should be disclosed. So you are going to ask yourself, first, does a record exist? And then second, is the requester entitled to access? Remember that the presumption is always that the public is entitled to access unless there is a specific reason why they are not. And that comes in with step number 3, which is the requester prohibited from accessing the record for some statutory reason or based on court opinion or something like that? And then does the balancing test weigh in favor of prohibiting access? So the guide goes through some thought processes for you on deciding whether or not there is sufficient reason not to release something if that is more in the public interest than releasing something. There's quite a bit of detail in this compliance guide, so I recommend you check it out before you need it. But when you do need it, is also really well done in terms of walking you through the process that you will have to go through to respond to a records request. So let's talk about who can ask for records and how they have to ask and when they can ask. And the answers are anyone, anyway, and at any time. You cannot deny a records request because someone didn't use specific language. You can't require them to put requests in writing. You can't require them to identify who they are. You can't require them to ask in a certain way. The presumption is that the public has access to your records. That doesn't mean you have to open your office up and let someone dig around in your files all day long. The request has to be reasonably specific as to the subject matter or length of time involved. So there cannot be any ongoing requests. Someone cannot come to you and say, I'd like you to send me all the correspondence you get from now until December about this topic. Those records don't exist yet, and the public cannot request records that do not exist. So you can deny that request. But they can say, I would like all of your correspondence on this topic from 2025 to date, and then that is reasonably specific and time limited. You would have to respond to that request. It needs to be specific enough that the records custodian doesn't have to guess at what the requester wants. So they can't just say, I need some records, and you just start handing over documents. It needs to be a specific request. And you can deny requests that would impair the normal functioning of your library. So if someone has requested something that is so burdensome that you're like, I won't be able to do any other work if I have to respond to this records request for the next 6 months, you can deny that request, but that can't be denied just because it's a large volume of records. Sometimes requests do turn up a lot of records and the public is entitled to those. So it's hard to put specific requirements on these things. Sometimes it has to be sorted out by the courts, but remember that the presumption is that records have to be provided. So you start from there and then you go forward. So how you respond to a records request, there isn't a ton of detail in terms of the timeline that you have to respond. You have to respond as soon as practicable and without delay, according to that compliance guide. And they suggest that 10 business days is a good guideline, but there's no statutory requirement. And if you're dealing with a very large request, it might take you more than those 10 business days to respond. So in that case, we do recommend that you communicate with the requester and say, we've received your request, we are working on it, we anticipate having some results for you by this time. It's okay to do that, but you do want to respond to those requests as soon as you possibly can. If a request is in writing, you must also respond in writing. If you, during the course of trying to respond to the request, you find records where there are parts of them that are confidential, but other parts could be disclosed, then you have to disclose those parts that can be disclosed. So the compliance guide has some more details on how you would go about redacting records for that. And then you can charge fees for records. You need to make sure that statements about those fees are in that records notice that I talked about right at the beginning of my talk. But you can charge your actual necessary and direct costs for copying, transcription services, photographic reproduction, locating costs if it's going to be $50 or more, shipping records. You can also choose to waive fees. The statutes allow for that. I do recommend having in your public records policy maybe a statement about when you might choose to waive those fees so that you can apply that evenly and fairly to all the requesters. If you must deny a request, you have to give a reason to the requester, and the reason must be specific and sufficient. So you would need to reference a part of the statute that covers the record you're discussing, or a court case, or some other specific exemption for why you cannot release a record. So if you have a very simple records request, you might get someone say, I would like copies of all your board minutes for the last 6 months. That's an easy request. You can easily comply with that. no problem. If you have something that's more complicated and you're talking about denying some records access, you may wish to consult with your library or municipality attorney for guidance, because it does get into some sticky areas. So I do recommend that any complicated requests, you're reaching out to get some guidance on that. You can also reach out to our office at the Bureau of Libraries. We can provide you general advice, although we can't give you specific legal advice. Your library system has people that are very knowledgeable about public records, so they are another resource for you. So there are reasons to deny or redact a record. 19.36 in the Wisconsin statutes has some of those specific reasons, but there are other statutes like 4330, which is the one that covers the confidentiality of library records that we talked about earlier. So you do need to be somewhat knowledgeable about those things when you are responding to a records request, which is where others can be of help to you. I talked earlier about the balancing test that's talked about in the compliance guide that can help you weigh the public interest in disclosure versus the public interest in non-disclosure. Now, if you do have to deny a records request, any records that are related to that request, you do have to retain for a minimum of 60 days after that records denial, even if the records have otherwise reached the end of their life, or 90 days if the requester is a committed or incarcerated person. So those are things that you must retain in case that person would like to go to the courts and ask for a writ of mandamus to force you to release those records to them or appeal such an action. So don't throw things away once you've been asked for them. Make sure you give them the proper legally required amount of time before you dispose of those records. And remember that responses to records requests are themselves records. So now you've gotten yourself caught in a little infinite loop of creating records. But so make sure you're retaining all of the documentation that you are generating about the request, including your response to the requester. You cannot create your own rules about what is exempt from disclosure. So I've had questions about that in the past. A library reached out to me. They had a policy about requests for reconsideration of library materials. And in their policy, they stated that those request forms would be confidential. You are not allowed to do that. You cannot place a blanket restriction or a blanket exemption on records through your own policy. You have to follow the state laws about public records. And pretty much the state laws are everything is a public record, except for a few exceptions. So that brings me pretty much to the end of what I wanted to talk about. I have 3 handouts here that our team has developed. The public records specialists within DPI helped me with these, and I have shared them with Emily, who will probably share them with you at some point, and I will also eventually be posting these on the Bureau of Libraries website. There's one document called Records Management in 4 Easy Steps that's just sort of an overview of the process. There's a flow chart that helps you decide about how you can and when you can dispose of records, non-records, and duplicate records. And then there's an FAQ that has, it's about 3 or 4 pages long with answers to questions that we commonly receive about public records related to libraries and library systems. And I referred a lot to the resources that I would share. Here they are. Our Bureau of Libraries has some resources on our website for you, including that Public Libraries and Public Library Systems GRS. The Wisconsin Public Records Boards is where you will find those statewide general record schedules. We've also linked them from our website, but the official versions are probably best gained from the Public Records Board. The Wisconsin Historical Society has a lot of information about retaining records and filing records and organizing records. And then the Office of the Attorney General is where you will find that Public Records Compliance Guide. You will also find information there about other sunshine laws, such as the Open Meetings Law. All right, so that said, I am done with my prepared slides. I am ready to take your questions if you have any. I'm going to pop my video back on, and I will probably stop screen sharing so that we can get some of your questions answered.
Thank you so much, Teresa.